What's up, YouTube? All right, we're live on TikTok and YouTube right now. Thanks. Sorry for the delay in my arrival here. I had to take a comfort break, in honor of Judge Glanville. But yeah, let's pull up the ruling here, because and what surprised me about this is, like I said, I didn't think he was going to get recused over this ex parte, and she even says in there that the ex parte is proper. Or she generally agrees with Glanville's assessment that the ex parte is proper. The ex parte is not what got him removed. It's everything he did after that. And honestly, my first reading my first take when I read this ruling, I'm like, oh, this judge, she must really not like him, because he's an arrogant prick. I mean, it's the way he handled this whole thing. I mean, she even straight up says in here that it's not the ex parte that everybody's just been freaking out about, saying it's illegal. She had a different take on that whole thing. Yeah, because I mean, of course, I didn't think there was any way he would get recused over that ex parte. And I've even said, it's like, it's not the ex parte that is weird. And somebody had to have taken him aside and been like, like I said in the other live, when he moved the recusal motion to another judge, that somebody must have taken him aside and been like, you're screwing yourself over here, dude. Like, you can survive this ex parte hearing, but the contempt order, everything he did after that is what screwed him over. Let me pull up the ruling here, because it's like, ouch, man. If he had just sent those recusal motions to someone else, he wouldn't have gotten recused. Like, if you just read the order, it's not the ex parte that really screwed him over. It's everything that he did after that. It's funny. This is like a huge blow to him too. I mean, I was gonna ask Joseph, because he's more familiar with the Fulton County process of like, what is the process for appeal here. But the idea that a court would like reverse Krause on this, I don't think so. It's a pretty solid ruling against him. So here it is. And I think it's funny because, I mean, I did say I didn't think he was going to get recused, because I didn't think that anyone would recuse him over the ex parte. So I just see some assholes on here like, oh, well, you got to listen to the lawyers. It's like, well, all the lawyers have been, not all the lawyers, but some lawyers have been screaming about how this ex parte was just totally illegal and there was all this stuff. And the judge in this order straight up says it's not the ex parte. It's everything that happened after that. But the specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. I'm reading the order here. It's 10 pages. Somebody asked about Brian Steele's motion to disqualify Love and Hilton. Because he kind of just threw that into a supplement to the motion to recuse Glanville. So he actually hasn't brought a formal motion to recuse them. So that's probably why she just didn't address it. Maybe he'll file another thing and actually call it that. And see, here is what really screwed him over. And I said this, people have been watching, like when he wrote that order, there's a line in there where he rejects the order, he rejects the recusal, where he kind of screws himself over, because he says the facts as alleged provide grounds for recusal or are sufficient for recusal. However, there's no evidence supporting it. But at that point in time, it wasn't time for him to look at the evidence. And by his first statement in that order, he basically says under Georgia law that this should be transferred to another judge. So he really screwed himself over there. But honestly, when I was reading through this order, I'm like, dude, Krause must not like Glanville. And just the way he is on the bench and everything, he's so arrogant and such an asshole to the attorneys. Like he isn't like that to his colleagues too, Like he thinks he can, throw a $2,000 donation to all the judges to like try to win them or something, but they don't care about fucking money, Yeah, the campaign donation thing was just like, She doesn't care about that. She got like $167,000 and Glanville gave her $2,000. I mean, the idea that she's like feels indebted to him because of that, you know. But that being said, it was a legitimate motion for the defense to bring. Like, they have to represent their clients. So if they think there's an argument, like even if it's like a long shot argument that Judge Krause should recuse herself based on that campaign donation, they needed to bring it. But she really showed that no, $2,000 from Judge Glanville back in April is not gonna change her mind here. But because recusing a judge, at least just where I'm in California, there's just like this whole political thing with it. You just don't really see it. And it's kind of a big thing. So this motion, I mean, like I said, they must not like Judge Glanville around Fulton County Superior Court, because this is really bad. So we're getting in somebody asked, what was he recused for? Exactly. It was his handling of the recusal motions, like the way he inserted new facts into the order. Like if the second he'd gotten those recusal motions, like Weinstein said, he should have sent them out to another judge, and he didn't. And reading this ruling, you can tell, like if he had sent those out to another judge, he wouldn't have been recused. But sorry, I was actually in court in LA federal court, and I glanced at my phone and saw this come up, and I was like, oh shit. I had to like run out of there, and all this stuff was going on. I saw this friend who wanted, and I was like, yeah, I gotta go. It was kind of frantic. But yeah, findings of fact. These recusal, and this is Judge Krause's order issued today. She said these recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office, alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7th, 2024. The motions to recuse all arise from the same circumstances related to state's witness, Kenneth Copeland. I hate how there's a comma there, because there's more than one state's witness, so anyway. On June 7th, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that, if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After the discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Judge Glanville excused the jury and then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th, 2024, at which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10th, 2024 at 8:30 a.m., and court was adjourned for the day. On June 10th, 2024, at approximately 9:10 a.m., Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, Kayla Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Ms. Love told Judge Glanville that she wanted the meeting to both impress Mr. Copeland upon Mr. Copeland the risks of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Ms. Bumpus, Ms. Love, and Judge Glanville also discussed the scope and the effect of the state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville's chambers, where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hilton, counsel for the state who had joined the meeting. During that time, the state advised Mr. Copeland that he would remain in custody until the conclusion of the trials of all defendants in the case, not just the 6 currently on trial. Judge Glanville discussed OCGA 24-5-507 with Mr. Copeland and his rights and responsibilities after a grant of immunity. Mr. Copeland spoke privately with his stand-in counsel, Ms. Bumpus, and then advised the court that he would testify. After the meeting and immediately before Mr. Copeland was brought out to testify, defendant Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt, though Mr. Steele was allowed to remain in the courtroom on behalf of his client, defendant Williams. She skipped over the fact where he was actually held in custody for, it was like 40 minutes that he was back in the holding cell, which is crazy. But that's fine. That's still an accurate conveying of what happened. And Judge Krause's order continues here. Ultimately, Kenneth Copeland did testify on June 10th, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear in show cause as to why they should not be held in contempt for disclosing information about the ex parte to defense counsel. An amended show cause order was later entered setting July 1st, 2024 for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse followed, filed by DeMonte Kendrick on June 12th, 2024. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. And notice how she included allegedly. And she never goes on to agree with those findings that it was improper and coercive. It was just everything that happened after that. It's pretty fucking interesting. But on June 14th, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and, quote, on cursory review, quote, contains assertions of facts to support the allegations of bias and impartiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require a referral to another judge for consideration. So on June 14th, 2024, Kayla Bumpus files a motion to quash the show cause order to recuse Judge Glanville or to recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus resulting from alleged disclosure of the ex parte meeting. On June 17th, 2024, Jeffrey Williams filed his motion to recuse Judge Glanville. Divorced from its hyperbole. Yes, seriously, guys. And this is, yeah, I love this judge. She obviously hates Judge Glanville, but yeah, she can read that motion and be like, calm down, guys. Divorced from the hyperbole. Mr. Williams' motion and supplement also seeks to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. I want to read this footnote here. Technically, Mr. Steele's counsel moved to recuse Judge Glanville from further handling of the contempt action during the June 10th proceedings. However, the motion was made orally, and it is not before the court because Mr. Steele's contempt matter is currently pending before the Supreme Court. Another footnote says, although referred to this court for consideration, Bumpus's motion to recuse is both premature and moot because Ms. Bumpus has not yet been held in contempt and because on July 1st, Judge Glanville canceled the show cause hearing. So this is just DeMonte Kendrick's and Young Thug's recusal motions here. Mr. Williams' motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became, quote, embroiled in a controversy when he held Mr. Williams' lawyer, Ms. Brian Steele, in contempt. On July 1st, 2024, the day appointed for the parties to review a redacted transcript of the ex parte meeting. Judge Glanville announced that he was releasing the entirety of the transcript of the meeting and was taking judicial notice of and making a record regarding certain matters associated with the meeting. Most of what Judge Glanville relayed was a coalition of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville advised that he had not yet instigated an investigation into surveillance footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his view that the meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned defendants' right to be present in the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were being referred for consideration by another judge in accordance with the Uniform Superior Court Rule 25.1 through 25.7. The motions to recuse were then assigned to this court for consideration. This is Judge Rachel Krause. Legal framework. We're getting into the heart of it here. Motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit, quote, clearly stating the facts and reasons for the belief that bias or prejudice exists. The affidavit must be, quote, definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate either bias in favor of an adverse party or prejudice toward the moving party in particular, or a systemic pattern of prejudicial conduct towards persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in that action. Bare conclusions and opinions are, quote, not legally sufficient to support the motion or warrant further proceedings. Once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. If all three criteria are met, i.e. the motion is timely, supported by an affidavit, and the facts alleged might warrant recusal, another judge shall be assigned to hear the motions to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 of the revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. The standard is objective from the perspective of a reasonable, fair-minded, and impartial person, rather than the affected judge or the interested parties. If a motion to recuse satisfies the three threshold criteria, the assigned judge must refer the motion for reassignment and may not, quote, oppose the motion. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory to the judge. No matter how false or even defamatory the judge might know or perceive the allegations to be. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without the defense itself becoming a basis for recusal. And these are quotes from actual previous case law. So, and this is funny because this isn't really in the recusal motions very much. This is kind of the judge coming up with their own stuff, I think. But here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. Yeah, he screwed himself by saying that. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e. that recusal might be authorized if the facts alleged in the motion were deemed true. Yeah, that is what did when he deemed that, but then didn't recuse over. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. Yeah, that's what he did. That's what screwed him over. It is worth noting that the court agrees generally with Judge Glanville's assessment of the propriety of the ex-parte meeting. That just makes this recusal motion just all the more brutal for him. While the meeting could have, and perhaps should have, taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of allegations, and otherwise explained the decisions and actions and argued why those actions were proper. This is so fascinating to me because the supplement that Brian Steele and Keith Adams filed after July 1st really did not look at that in the case law. It was just all about the transcript and all about the misconduct that occurred in this ex parte. And it's like, no, the judge found like a whole other reason after that, and like kind of goes into her own case law here. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is as objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as to the recusal issues and in ruling on Kendrick's motion, Judge Glanville, quote, evaluated and accepted the truth of his own factual allegations, mandating the recusal. This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. I'm like, okay, I think this ruling tells us everything we need to know about what Fulton County Superior Court judges think of their arrogant prick chief judge. Like, I mean, seriously, this is bad for him. Anyway, I see Joseph here Joseph from Atlanta Journal-Constitution is going to join us for a chat here. He won't be, you can't see him on TikTok, but he'll be on screen here on YouTube. And he's been covering this case forever. He can get into the politics of it. Let's see. Thank you so much for joining us.
Hey, can you hear me?
How's it going? I've got you on screen. What's up?
Okay. Can you hear me?
What a big news day today. So how did this go down? First of all, how do you, because you can't get notices for the Superior Court file. Did you just get an email or were you just getting refresh?
So what happened is that I was actually eating lunch. Then I got a text from a former attorney in the case, Suri Chara Jimenez, saying the recusal granted, and I was like, "Oh, I need to get on this." And I've been working with our attorneys, our AJC attorneys, who do get the filings as soon as they're filed, and they're being able to send it to me because for some reason the Fulton County website doesn't work for me in terms of buying stuff since they hacked.
Yeah, I haven't been able to update my.
Since the hack that happened, so I cannot really buy anything, but luckily this attorney that we have gets the filings, and she's been sending the filings to me. So that's why I get them up not as quickly as Target Daily, but I try to get them up as quickly as possible. And of course, this is the big news of the day, and this is the news that we've been waiting on for ever since he held the proceedings.
Yeah. No. So were people expecting this? I mean, kind of the general thought is that judges kind of protect themselves, and especially the fact that I felt like some of the allegations of misconduct and stuff in that meeting were a little overblown, which she basically says the same thing in that order. But to me, this reveals a lot about the politics of the court.
So we wrote a couple of stories last week, especially when all the motions were being filed or the responses were being filed. And we wrote a story on Friday in which we talked to two people who were former Judicial Qualification Commission chairs. So they know about judges and those are what police judges here in Georgia.
Yeah.
And they were saying that they didn't think that he was going to get recused. Just because, like you mentioned, it's like sometimes judges protect each other and stuff like that, and they didn't feel it was enough, or even that Krause would decide to do this ruling herself. Even if she denied it, she probably might have prefer for the Court of Appeals or the Supreme Court of Georgia to make the decision instead of her on what to do with a judge on this high-profile case. But in the end, as you can see in the motion, in the order, she decided, hey, let me just recuse Judge Glanville from this. And yeah, it's we'll see what happens with Judge Ingram. She does have the chance to uh, recuse herself as well from the
Yeah,
case.
yeah.
So the way it works in Fulton County is that they have like a random wheel that assigns judges to cases. So I guess Judge Ingram was the next judge to be assigned, needed to be assigned, but she could also recuse herself for a variety of reasons, from like knowing Judge Glanville, having something with Glanville, or knowing the prosecutor, or knowing some of the defense attorneys, or like a variety of reasons. The judges can recuse themselves for a variety of reasons. So we'll see if Judge Ingram decides to take whatever happens next, or she decides to send it to another judge.
And
Yeah,
so
that's her.
this is Judge Ingram, the judge who's been assigned to the case since Glanville. Have you do you know much about her? Have you seen
I I I
Krause work?
tried to ask colleagues about her, and the only thing we could find right now is that she presided over a case involving a former East Point. East Point is an area here in near Atlanta. A police officer accused of sexual assault who was acquitted of 7 counts. And that was in 2022. But I've heard the name before. I've heard the name before, and again, it's not as well known as Glanville or McAfee or right now also Kimberly Adams, but we'll have to see what she decides. No, nobody really knew Judge Krause anyway, and she basically just decided, hey, let's get rid of Judge Glanville and have another judge handle this.
Yeah, wow. Wow.
So
So is it, I mean, is there like kind of some shock in the legal community because of this? Because I mean, like you said, the vocal people on, well, this is me saying this, the vocal
yeah,
people on social media have been saying he's been recused, but like you said, you talked to a couple of people who last week who didn't think he was going to be recused from this. And that was kind of the general thinking. So is this just total shock?
uh, it really depends, because what Judge Glanville did, especially after holding Brian Steele in contempt, was, I don't want to sell the nail in the coffin, but that was like a lot of defense attorneys from not only Georgia but all over the country went after Judge Glanville because of what he did to Brian Steele. And Brian Steele is like a great defense attorney that everybody here in Atlanta knows. So it's like from there was a lot of negativity towards Glanville, and then a lot of people thought he might be able to stay on the case. Other people thought he might not be able to stay on the case. The funny part that I found from the order is that Judge Krause didn't think the meeting was improper. She thought what Glanville did after, on July 1st, when he held the proceedings, that's the reason he's being recused, not because of the meeting.
Yeah, I thought that was so interesting because I mean, everyone has just been screaming about how that meeting. I mean, that was why I didn't think he was going to get recused, because I thought, like she said, the hyperbole about. She even uses the word hyperbole in that order to talk about just what they were saying happened at that meeting. It didn't seem to rise to the level of that, and the order confirms that. But then it's everything that happened after that. So, what can prosecutors appeal this? I mean, what do you think the chances of that happening?
Actually, uh, and I don't want to give too much away because, actually, it's in the story right now. We just
Oh, sure.
updated our story. So in our story, we talked to Don Samuel, he's also a prominent defense attorney here, and who also represented Ghana in this case.
Yeah.
And he said that the DA's office does not have the right to appeal a defendant's successful motion to recuse a judge. So
Yeah.
the
Okay.
DA's office cannot recuse, it cannot appeal this decision by the
Yeah.
judge to
It
recuse
does. If
Glanville.
they could, it doesn't seem like likely that a court would be willing to
Yeah.
be like, "Oh, Krause, you're wrong."
And also, you probably read the response from the DA's office. It wasn't that like, yeah, we Glanville needs to stay on. They were basically saying Glanville needs to stay on, but they didn't really give a lot of argument in terms
Well,
of why
well,
Glanville,
they
which
obviously.
which which would have been difficult to do because he was like, you don't want to appear with that what Steele alleged that Glanville had become part of the prosecution and give more fire to that, more wood to that fire. But I just don't know what the goal was with that response because he didn't like give a lot of, he didn't have a lot of meat on that bone, in my
Well,
opinion.
I think their logic on that was kind of reflected in the order, and that there wasn't anything really wrong with that meeting.
Yeah,
Like
yeah.
in the idea that his actions afterward, like I mean, that's what Judge Krause said, but I don't think they really felt the need to respond to that because nobody ever even really raised that. Like in the
Yeah.
supplement to it was just all about the transcript of the ex parte and like look at all this, you know, improper conduct that went on, look at all the badgering of the witness, the
Well, and
coercion. And no
even
one
like,
even brought up all this case law and what Judge Glanville said on July 1st. The attorneys never even made that argument. The judge just found it
yeah.
herself and used it to recuse him. She must just fucking hate Glanville.
Uh,
I mean, that's what I
I,
think.
I won't comment on that. I won't comment
Yeah,
on that. I'll let you handle that. I'll let the Twitter users handle that.
sure.
But we'll have to wait and see what Judge Ingram decides to do
Is
because
it is it a given that there's going to be a mistrial and the trial is going to start over?
not necessarily,
That'd be weird.
but because right now, and I haven't checked the filings, but I haven't received any. Steele and Kent and Weinstein and all the other attorneys need to file the motion to mistrial first.
Yeah.
And then what needs to happen is the judge, Judge Ingram now, needs to decide, okay, am I going to stay on this case and have to go all through all 18 months of transcripts, all 18 months of decisions, all 18 months of everything, and then get caught up and go on from June 10th forward? Or am I just going to, the defense is going to have enough argument for a mistrial and I'm going to declare a mistrial? Now, the key is if it's going to be a mistrial that with or without prejudice. So we just had the Alec Baldwin, what
Right.
happened with him, and that was dismissed in totality. So there's no, like, he cannot be recharged with that. But here it could be like, oh, you can go again,
Yeah. Yeah.
or Young Thug goes free. One
So
thing defense attorney should be able to do, and I actually got a statement from Doug Weinstein, is like they should be filing motions for bond.
yeah,
For the new
which
motions
will
for
come
bond.
first, the motion for mistrial or the motion for bond?
Uh,
Who knows? Probably the same time.
yeah, probably at the same time, but I would try to file the motion for bond first, and then for motion for mistrial because the motion for a mistrial is might take longer than a motion for bond.
Yeah. Yeah.
And also,
So
it might end up that Judge Ingram just denies the motions for bond anyway, for the same reasons Glanville has denied all the motions for bond. But we'll have to see. I
yeah,
did, yeah,
it'll be interesting to see how much of what's already happened is redone because the order from the recusal order gives no reason to think that, you know, anything improper has happened in the trial other than just him having a big ego and refusing to send these recusal motions out to another judge. I
yeah,
mean, that's really the only thing she identifies in there.
yeah. She didn't. She even says that while perhaps the meeting should have been held in open court, there was nothing improper about the meeting.
Yeah, yeah,
And
and that's
that was the whole argument with Steele and Weinstein. Is like we should
oh
have
yeah,
been there. Everything was wrong. They coerced Copeland, and they forced Copeland to testify and all that. And then the
yeah.
judge was like, Judge Krause was like, no, everything is fine. It's
Well,
just Judge Glanville.
it's just so subjective with that because some people are just
Yeah,
like, oh, this meeting was obviously illegal. I'm like, no, it wasn't. It really is just subjective. Like a judge friend here in California read through the transcript and he responded that while he thinks the basis for the meeting was probably maybe proper, he said it went way beyond anything that would have happened. And then he specified that would have happened in my court. Because yeah, it's just up to like the judge's personal preference. You know, he wouldn't have gone all that into all the discussion with Woody, but that, there's just no saying, there's no like just like objective way to tell whether that was just illegal or not. It's just like a judge's opinion. And God, it's kind of, I don't want to say because it's not a loss. It's a huge win that he got recused, but it's so bizarre to me that she kind of just came up with her own reason to recuse him that wasn't even raised in the recusal papers.
Yeah, and a lot of the criticism of Glanville, it was warranted, in my opinion. Now that he's been recused, but at the same time, he's the chief judge of Fulton County.
Yeah.
He also handles Veterans Court. I forget his official title with the military, but it's not like he's a rookie judge.
Yeah. Yeah.
Like and like, yeah, sometimes he does rule in favor of the prosecution. A lot of times that they rule in favor of the prosecution, and he must have his reasons why he does that. But I never had a problem with Judge Glanville, only with his time management skills. But other than that, I feel like he might have gotten a bit overwhelmed with everything that's going on, that's happening with this case.
Yeah.
And yeah, we'll have to see what Judge Ingram does. One thing with Glanville is like he did give a lot of access to the media. He did approve a lot of Rule 22s, and some judges in Fulton County are not like that. So
Yeah. I mean, it's judge's discretion whether to allow
yeah,
cameras in court, right? I mean, the
yeah,
Georgia law favors cameras in court, but they don't have to allow them, right?
yeah. There is a judge, like there's the training center Rico case right now as well. The judge presiding over that and doesn't like cameras in the courtroom, doesn't like cell phones in the courtroom. So it's really hard to do your job as a journalist in that courtroom. But with Glanville, it was like more open in terms of open courtrooms, but still, just certain things the way he managed certain things is just, and like, it was not all on Glanville, because Glanville's not the one that had a deputy message a defendant and fall in love with a defendant. Glanville's not the one that had a juror go to the Dominican Republic when she needed to present for jury duty. Glanville was not the one that emailed the jury services saying that everybody's guilty and you should accuse me from jury service. Like,
So these are
yeah,
other judges that you've written about then in Fulton County then?
no, these are all the jury selection problems and everything that
Yeah.
happened in this trial
Oh,
that
yeah.
Glanville doesn't really have control over, but still he's the presiding judge of this case, and he should be able to handle this better.
Yeah.
What?
Yeah. It was, I mean, the case, it seems like it's just too big, period. Any judge would be kind of like struggling to get their arms around it, but he really seemed to, the complex case was just not, not good for him. It seemed
And
like.
and like now Glanville is handling another high profile case here. I don't know if you heard of it's called the spa shooter. There was a shooting at different Asian spas here in Atlanta a
Oh
couple of
yeah.
years ago, and he's already sentenced for life in prison in Cherokee County, a neighboring county. But Fonnie Willis, the DA here, decided to seek death penalty here for Fulton County charges. So he's presiding over that case. So that would be his main case right now,
That'll
and you
be,
have.
and that one gets filmed, right? Or streamed online when there are big hearings.
Yeah, but the last couple of hearings has just been talking about brain matter and whether his brain was fully developed when he committed the crimes, and a lot of like really technical stuff that
Yeah.
doesn't really sell newspapers. Let's just say that, or doesn't
Yeah.
really
So
interest a lot of people.
I was trying to think when is like, because we're never going to see Judge Glanville. I mean, for people who just watch the stream, I mean, he's gone. There's no reason he's ever going to be
Yeah,
on the stream again. I would just love to know, like, what is he doing right now? What's his reaction to this? I mean, this is a
I
huge, like,
yeah.
this against him.
I reached out to his court reporter to see if that maybe through her Glanville might want to say something, but I doubt Glanville is gonna come out and say anything.
Yeah, no, it's the kind of
Like
thing where you just
it's
have to run
yeah,
into him.
it's like let's just move on. Let's
Yeah,
just
you would just have to run into him when he's leaving the courthouse to go get to his car or something. Be like,
we're walking his dog.
yeah,
Uh,
yeah, gosh,
I'm gonna miss hearing that dog.
yeah,
I, I
yeah.
I like over this trial has been going on for 18 months now, so you get to meet some of the people that work with Glanville. And I told the court reporter, I'm gonna miss seeing you every day that I go to court, and but that's the way the legal system is, and I guess Glanville made his own bed based on what Judge Krause said on
Oh
the.
yeah, he was his own worst enemy, and somebody obviously like when he came out on July 1st and was like, I'm sending these to another judge. It's like clearly he probably had some friends like counsel him over the weekend about, you're just making this worse for yourself. But then it turns out those comments on July 1st, that's what did him in. I mean, him not sending the recusal notice.
If you and I haven't been able to confirm this, or and I think it's useless now. But if you go back to watch the June 10th here proceedings, when all this happened, the meeting and all that, and even you read the transcript, you notice that one person is not there, and that's his attorney, Wesley Kearns, who sits right in
Oh,
front of Glanville.
yeah, yeah, yeah.
Like that's something I noticed instantly when I was watching back and all that. It's like, where is he?
Yeah, you think because
It, it, wa- it,
when
was,
I
it, was,
read his first order, it's so obvious. It's so different from federal judges who have like, a rotating two top law school grads as their law clerks and rotate out every year.
it
Superior
might
Court
have been,
judges don't
yeah.
have that. So just
It might have
reading
been,
through his order,
yeah. He
it's
might
like,
have been on vacation or something. I don't want to speculate on what he was doing, but uh, just something
interesting.
curious. It was like, well, like because that's your staff attorney. That's the one that tells you, that assesses you and helps you out, and could have probably helped out Glanville a lot that day with
Yeah,
everything that happened after the meeting, with still being held in contempt and all that.
yeah, yeah. The contempt thing was totally crazy. And then his written order for Diamante Kendrick, he totally dug himself in a hole by saying, oh, this is sufficient as pled, but there's no evidence. Like, yeah, I mean, as Judge Krause said, he should have sent the orders out to another judge after that. But
Honestly,
wow.
he should have just, as soon as now that I'm reading the order, it's like he should have just taken the motion to recuse and say, okay, I'm gonna just give it to another judge, not read the whole thing that he read July 1st, because
Yeah.
that's what got him off this case, what he read
Yeah.
on July 1st.
Yeah.
Not
Yeah.
anything else. Not anything
That's
else. Just what he read on July 1st.
man, that that just makes this all the more brutal. I mean, him getting recused, period, is just it's bad for him. It must, but that just must hurt. It wasn't the meeting that did it. Like she even says that she even uses the word hyperbole to describe some of the criticisms of it. But it's everything that happened after that. Wow. Um, so, do we have any idea on a timeline here? I mean, it's impossible to predict. But are you expecting
Well,
something with this new
well,
judge this week?
the first thing that needs to happen is Steele and Kendrick, and I guess the other attorneys, have to file the motions for a mistrial, or the motion that Bruce Harvey likes to always uh, file, is motion to sever
Yes.
the case, and he always gets denied. Well, he might get that motion granted now
Yeah.
if he files one, but they're probably gonna file a motion for mistrial. It would just depend when, and if, because we don't know if Krause wanted to have a hearing on this or just rule from the filings. But Judge Ingram can also do the same, or just have a hearing, or again she could recuse, and then it goes back on the wheel, and the judge can reassign.
Yeah. Yeah. Gosh. Gosh. Well, how exciting. So big, busy day for you guys. Are you guys like planning more coverage this week or I mean, I think it has been
Yes, yeah. Well, and then if anything big happens, then yeah. But our focus is mostly on the Republican National Convention this week up in Milwaukee. So we've been covering that, and as soon as the order was filed, I wrote a quick something to have on our website, and we had the breaking news banner on there, and then like 10 minutes later, it got replaced because Trump announced his BP pick.
Oh yeah, JD Vance.
So,
Yeah,
so it's that's news. That's news. It happens all the time. It happens
yeah,
all the time. At least it wasn't a Friday news dump, you know,
yeah. No, it's nice she
because
didn't
that
decide to do that
yeah.
Friday evening.
And it's nice that she decided to do it like at 3, so it was like it gave us enough time for print deadlines and gives enough time for the TV people to have their story ready for the 5 o'clock, 6 o'clock news. So
Yeah,
we'll have to
yeah,
wait and see what Ingram does. But yeah,
yeah,
we'll continue. You know this. We'll continue to cover this story uh, until the end. So if you guys want to download our app or subscribe to the AJC uh, to read our coverage, and you probably won't see a lot of Shoddy in our coverage for YSL this week because you got seeing Milwaukee this week. But
yeah.
I'll be holding out the fort down here and and reporting everything that I find out.
Awesome, awesome. Well, hey, thank you so much for joining us.
All right.
Anything else you want to say, or something we didn't cover that you think we should get in?
No, we'll see if we'll see what happens. You never know what can
Yeah,
happen.
yeah. Hopefully, all the hearings keep continued being streamed.
Yeah.
But,
I
yeah,
will I will say we did reach out to Brian Steele and DA Fannie Willis, and both declined to comment on this. Doug Weinstein did wanna comment, so he sent me a statement that we having our story up right
yeah.
now. So
Okay. Okay. Cool. Well. Hey, thank you so much for
no,
everything. It was
thank you for having me.
keep following your coverage for sure. Everybody, check them out
All right,
on Twitter and Atlanta Journal Constitution. Thank you
all
so
right.
much, Joseph.
Thank you. Bye
Thank
bye.
you. That was great. That was Joseph from Atlanta Journal Constitution. He's actually there at the courthouse, sees everything. Oh, and hey, I see people saying there's no sound in my TikTok video. Sorry, I'll just have to redo it. I don't know what is with that freaking green screen thing that screws me over, but I'll just have to redo it. But yeah, so big news, guys. I went over the hearing. I went over the ruling in the beginning. So if you're just joining, rewind, check it out. And somebody says, I am a great journalist. Thank you. Thank you. I appreciate that. Yeah, because I mean, like I said, people are like, yes, I am. Somebody on TikTok asks if I'm live on YouTube. And yeah, I just I've got the YouTube video right in front of me on my laptop. And then I've got another phone that I put up right here to try to do TikTok too. So really, I get more out of going live on YouTube than than anything else. So yeah, I mean, I was surprised. Like I said, I didn't think that he was going to get recused over that ex parte, but clearly, like the judges within Fulton County are tired of their chief judge's like egotistical attitude. But he screwed himself over. So yeah, I'm going to keep following this and everything. Obviously, it's a fluid situation. And guys, cross your fingers, say a little prayer if you're into that stuff, that all this stuff continues being streamed online, because that's what I was afraid. I was always just like, dude, be careful what you wish for, because Glanville is kind of awful, but overall he's like a friend of the press, and that he never turned off the cameras at all. And I don't think there was ever a chance that he was going to turn off the cameras. So hopefully, because of that, this new judge who has the case, or whatever judge ends up with the case, feels pressure not to turn off the cameras, because that would suck. But like Joseph was saying, they could. And he was saying there's a judge there that doesn't like cameras. So if this case had gone to him, we'd all be kind of screwed. So hopefully all the hearings still continue to be live streamed. But it's really, being in California is really out of my hand. And I know the Atlanta Journal Constitution and the Atlanta TV stations are all on that. So they're taking care of things. But yeah, just to go over what happened, Judge Glanville is off the case. Let me pull up the order here. Give us something to clip here. And again, I think it's interesting that it seems like from my experience, there would have to be a mistrial here, but it's not like just guaranteed that there's going to be a mistrial and that the case will start over. I would lean toward that, but you know, I mean, Joseph was saying that there isn't like it's you don't know. So. You guys hear me? Gave me something about, gave me some kind of notice about screen share losing access to audio or something. So if on YouTube, for some reason, you can't hear me, let me know. But scroll down to the bottom here. Yeah. Breaking news, guys. Judge Glanville is off the Young Thug YSL case. He is off the case. Judge Rachel Krause recused him from the case today. Big news, big surprise too, because she even says in her order that the ex parte hearing that everyone was complaining about, that was the basis for the recusal motion, she doesn't see anything improper with it, or she agrees generally with Judge Glanville about the propriety of it. It's everything Judge Glanville did after that screwed him over. He's his own worst enemy here. It's how he handled the recusal motions, the order that he wrote, his refusal to recuse himself from the recusal motions. He really screwed himself over. And then July 1st, when he decided to basically try to save himself by coming out and sending the recusal motions to another judge, those comments that he made all around that are what formed the basis for his recusal today. Judge Krause even says in here, it just blows me away that she says it's not the ex parte hearing. She agrees that this could be a legitimate reason for a meeting. It's just everything he did after that, the way he responded to the recusal motions, trying to passionately defend himself and put facts into the record. She said that forms the basis for recusal. So what's really interesting is, while this is like such a huge victory for the defense, when you read through the defense recusal filings, they did not really raise these issues at all. You'll remember the supplement that Keith Adams and Brian Steele filed after July 1st was all about the transcript of the meeting and all the misconduct that they said occurred, the badgering of the witness, the coercion of the witness. And it turns out that Judge Krause really wasn't persuaded by any of that, but she had her own reason for recusing Judge Glanville and came up with it based on case law and his July 1st comments. Really, really kind of a remarkable turn of events here. So again, this goes to another judge. It's already been assigned to another judge. We don't know if she's going to stick with it, but this is her right here. Again, we don't know exactly what she's going to, if she's going to stick with the case, but it's a big question about what's going to happen in the next coming days. But I would expect to see a motion for a mistrial, a motion for bail, which Doug Weinstein had talked before about how they didn't think that had any chance. A motion for bail reconsideration would have any chance with Glanville, but obviously if they got a new judge, they were hoping for that. So I think we're going to see that in the next week or so, but it really is just a big question of when could this trial proceed again, because I think they're going to have to call a mistrial, but again, that's not even a given. But I mean, are we going to see anything before the end of the year? Are they just going to restart next year? I mean, I'm just not sure, but we'll see. But thank you guys all for tuning in. I've got a few hundred on each TikTok and YouTube. I gotta get off, so I want to redo my TikTok video. It's annoying that the sound didn't go off on that, but again, Judge Glanville has been recused from the Young Thug YSL case. This is Judge Rachel Krause's order today. And if you get into the details of it, she says that it's not the secret meeting in chambers that he had with prosecutors and Kenneth Woody Copeland that did him in. It's what happened after that. It's the way he responded to the recusal motions, the way he decided to defend himself, and instead of just sending the recusal motions to another judge. She cites all that as a reason to recuse him. It's pretty interesting because these aren't the arguments that were raised really in the recusal motions against him, but the judge found them out on her own and has her case law in there supporting recusal. So again, this goes to another judge. We don't really know what is going to happen with the trial. I think there's going to be a mistrial, but we can't say for sure yet. So we'll keep following it, and I'm gonna go redo my TikTok video that didn't have the sound. And thanks for the love, guys. Thanks for all the support and everything. And I know Doug Weinstein was saying that he should be able to join me on YouTube. He's just kind of busy right now, so maybe in like an hour or something I'll go live again with him. So check it out. Thank you guys so much for tuning in. I'll see you guys later. Thanks.